welcome back. Today we will be discussing minor's agreement, or some people even call it minor's contract, under Indian Contract Act, and that includes the epic mohoribibee case. Now this is one topic which remains relevant no matter what exam you're preparing for. Law school, CLAT, judiciary, judicial services exam, every exam. This is one topic that remains relevant. First of all, let's take a look at the law involved. That would be section 10 and 11 of the Indian Contract Act. So section 10 says what agreements are contracts. It says all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object and not expressly declared to be void. So for any agreement to be a contract, it is one of the essentials that the parties must be competent to contract in addition to other things. But this is the one that we're going to be focusing on today. Who are the parties who are competent to contract? That is given under section 11 of the Indian Contract Act, and it says that every person is competent to contract who is the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting. So only competent parties can contract, and to be competent, you have to be the age of majority. Now, you may ask, what is the age of majority? Majority, as defined by Section 3 of the Indian Majority Act, means that any person above the age of 18 years is a major, unless there is a guardian appointed, in which case the age of majority will be 21 years. So you have to be a major to be competent, and you have to be competent to be able to contract. So far, so good. Which means that all you minor babies out there trying to land a contract, you are out of luck. Too much? Okay, let's just move on. So where does a minor's contract stand? Before the epic mohoribibee case, the English law provided that a minor's contract or a minor's agreement is a voidable contract. And this was same in India also up till 1903, when one little baby boy named Babu Dhamodas Ghoshe made history with his case. So let's look into that historic case now. In 1902 was filed the case of mohoribibee versus dhamodas Ghoshe, which was finally decided in 1903 by the Privy Council. And for those of you just tuning in, Privy Council was the highest court before the Supreme Court in pre-independent India. So what were the facts of this case? Let's find out. In this case, the plaintiff was Dhamodas Ghoshe. He was a minor and he mortgaged his property in favor of the defendant, who was a man named Brahmodat, and he was a moneylender. Dhamodas Ghoshe, let's just call him DG, wanted to get a loan of 20,000 rupees. But Brahmodat, the moneylender, was out of Calcutta most of the time, and all the dealings in this case was done by his agent, whose name was Kedarnath Mittar, who acted on the behalf of the moneylender. Now this agent had full knowledge that the plaintiff, that is Dhamodas Ghoshe or baby DG, was a minor. He knew that, yet he got a declaration from baby DG saying that he was not a minor. Now that's just evil. Okay, that's evil, Kedarnath Mittar. That's not cool. But our baby DG was also smart. So he filed a case through his mother saying that he was a minor when the mortgage was executed, and therefore the mortgage was void and inoperative, and that the same should be cancelled. So the defendant, who officially was Brahmodat, contended that the plaintiff had fraudulently misrepresented his age and that he had a declaration from baby DG stating that he is not a minor and therefore no relief should be given to baby DG. And if the mortgage is cancelled, then baby DG should be ordered to repay the sum advanced to him. So the Privy Council went on to hold that the contract of a minor is void ab initio, that is void from the very beginning. That is, minor has no competence or capability to contract, so he cannot even get into a contract. You can't even call it a contract. It is void ab initio, and this is essential to protect the minor against his own bad judgment. Take that, Kedarnath Mittar. The court went on to hold that the general presumption that every man is the best judge of his own interest is suspended in the case of children. And this law still holds good and has been reiterated by the Honorable Supreme Court in the case of Vali Singh versus Sohan Singh, which is a 1954 judgment, and also in the case of Padma Vithoba versus Muhammad Multani, which is a 1963 judgment. So the contract of a minor is void ab initio. Now you may ask, is the contract of a minor void ab initio in all cases and there are no exceptions? To which I will tell you, no, there are exceptions. Sometimes a minor's contract can be valid and sometimes it can be voidable. So, which are those contracts? Let's find out. So, what are the examples of a valid contract of a minor? Firstly, beneficial contracts made by or for the minor can be enforced in minor's interest. Also, as per Section 7 of the Transfer of Property Act, a minor, though cannot be a transferor, but a minor can be a transferee, which means that he can be a mortgagee or a purchaser of a property, or he can be a donee of a property. And all these contracts can be enforced. And this has been held in the case of Raghav Cheriyar versus Srinivasan. Also, contracts by guardians for minors' benefit can be enforced. And it is also good for you to know that a minor, though cannot be a partner in a partnership firm, but can be entered to the benefits of a partnership. Some contracts of minors are also voidable. For example, Section 8 of the Hindu Adoption and Maintenance Act makes certain contracts voidable at the option of the minor. And it's also important for you to know that estoppel or promissory estoppel cannot apply to minor, which was also held in the case of mohoribibee, and that the general rule of estoppel cannot defeat the provisions of the particular minor's contract law that we just discussed. Also, there is no liability in contract or in a tort arising out of a contract for minor, which was also held in the case of Jennings versus Rundall. And I possibly butchered that name in pronunciation, but you can see the spelling on your screen right now. You may ask, is it possible for a minor to ratify a contract that he entered in his minority once he becomes a major? The answer to that is no. A minor, once he becomes a major, cannot retrospectively ratify a contract entered in his minority, because that would mean that he had the capacity to enter into a contract when he was a minor, and that's not true. Hence, he cannot retrospectively ratify a contract. This was held in the case of Suraj Narayan versus Sukhu Ahir. And now the final topic of the day, restitution. Can the minor be made to restore whatever benefits or money or property he got in the minor's contract? Can he be told, please return all these things, please return the money? Is restitution possible? So, under English law, it was held in the case of Leslie versus Shield by a King's Bench court that there can be no restitution against a minor. If goods were given to him and he still has them, he may be ordered to return the same. But if money was given, then there can be no restitution, as that would amount to enforcing a void contract. This case also had the very famous quote of restitution stops where repayment begins, and this quote is often given in exams, and this is where you say everything about restitution and minor's contract. So what's the Indian law on it? The Indian law on restitution against a minor was also consolidated in the mohoribibee case. In that case, the court went on to hold that no restitution of money can be done from the minor under Section 64 or 65 of the Indian Contract Act, which talks about restitution. And the reasoning given for it was that the contract of minor is void ab initio, and these sections only talk about a voidable contract, or a contract that later becomes void or is discovered to be void. So hence it is not voidable, it is not discovered to be void, it is void ab initio from the beginning. Hence no restitution can be done under Section 64 or 65 of the Indian Contract Act. And also no restitution was allowed under the Specific Relief Act in the mohoribibee case, because in that case the moneylender knew about the minority of baby DG. But it is good for you to note that restitution can be made under the Specific Relief Act, but it depends upon the discretion of the court. In mohoribibee case, it was not allowed, but it can be done under Specific Relief Act. And one last section that you might want to read on your own, which deals with a minor directly, is Section 68 of the Indian Contract Act, where it talks about a quasi-contract where necessaries have been supplied to a minor. Now, if you have to write any exam, you won't have any time to write more than what you have learned today. So understand these basic principles well, keep revising them over and over again, and you're good to go. And we hope you had some fun, hope you learned something today. Be sure to subscribe to our channel and come back soon for more.